Okay. Transnational Legislative Borrowing Act. So, I can see some of the participants. Okay, so that really gets me to the start of the genesis of why I wrote this paper. I was working on an arbitration in London when this whole thing began. So I'd like to really thank everyone. My apologies for not being able to present yesterday. Special thanks for allowing me to present virtually. Let me just get started and talk a little bit about how this paper began, what the genesis of this paper was. I was working on an arbitration in London. The photograph that you see is a photograph of all the people, my sort of colleagues who were working on this arbitration in London. And, one of the rules that came up at that time was under the Indian Evidence Act, which is Section 65G, which deals with secondary evidence. Now, one of the most important things in a trial is that there's this rule called the best evidence rule, which is that the best evidence for proving any document is to produce the original document itself. So if the original document is there, then you better have a really good reason why the original document isn't there. Then you have to produce secondary evidence. So there's this peculiar rule in the Indian Evidence Act in Section 65G, which says that when the originals are too voluminous or they're extremely overwhelming, then a summary will be prepared, and it's the summary which will be read in evidence as an exhibit. So when we came across this rule for this arbitration, my senior who was sitting beside me, who you see in the photograph, he asked me to look up comparative English on the subject. It was assumed, and it was a fair assumption, that we get all our law from England, and so potentially there might have been a similar rule in England. So he asked me to look up the books on English law and come up with some English cases on the subject. So I went the route, I looked at Fiction on Evidence and the standard English treatises on the subject. And I was perplexed by the fact that I couldn't find any contemporary comparable rule in England which correlates with 365G of the Indian Evidence Act. So that got me interested, and that's when I dug a little deeper. Siddharth, if I could ask you to move on to the next slide. So now you should be seeing Section 65G of the Indian Evidence Act. The words of this section are particularly important, and especially as a litigator, for me, words of a section are really important, so I'm just going to read it. It says, when the originals consist of numerous accounts or other documents which cannot conveniently be examined in court, and the fact to be proved is the general result of the whole collection, then secondary evidence can be read. So the reason I read the words of this section is because I found that the words are very similar to something that was prepared in the US in 1850. If we could move on to the next slide. So there was this in the US called David Dudley Field. In 1850, he prepared a code for New York. He was a part of a legislative commission in New York, which prepared a code which is now popularly referred to as the Field Code. This was a code on civil procedure. Now, Field at this time was a very prominent lawyer. He was very wealthy. He was educated at Yale. But of course, like most American attorneys, most American advocates, he wasn't an Oxbridge, barrister. So he probably didn't come from the same stratum of English, obviously, same stratum of society as Stephen, who I'm going to introduce a little later on, came from. So if we could go to the next slide, we'll see that in 1850, Section 1688 of Field's Code of New York contained a section, and I'm going to read the words again. It said, when the original consists of numerous accounts, words that are found in Section 65G, or other documents, which cannot be examined for a great loss of time, and the evidence sought from them is only the general result of the whole. So again, words like numerous accounts or other documents cannot be examined in court, general result of the whole. These words seem to have been copied from this section into Section 65G of the Indian Evidence Act. But the question that I asked myself then is that perhaps both Stephen and Field brought both these sections from the same source. Is it not possible that there was some common law rule in England And David Dudley Field got his rule in 1850 from that source, and James Stephen got his, basically wrote section 65G based on the same source. So if we can go to the next section, the next slide. So a little bit of a background. Of course, I think to this audience it may not be necessary. Everyone knows that the Viceroy Legislative Council is responsible for making laws in British India. But there were two precursors to the 1872 Evidence Act. The first was Act 2 of 1855, which was the main precursor to the Indian Evidence Act. And it didn't contain any comparable rule to Section 65G. The second was a draft which was prepared, a draft evidence bill prepared in 1868 by the Indian Law Commission under the chairmanship of Sir John Colonial. This, and by the way, James Stephen had a very poor impression of this draft of the Indian Law Commission. And this didn't have a comparable rule, to what Field prepared in 1688 either. So it's very clear to me that this rule came in, the 65G came in only after Stephen came to India. So if we can go to the next slide, you should be seeing a photograph before you of Sir James Stephen, who was responsible for drafting some very important statutes in British India. He is often given a lot of credit for drafting the Contract Act, but it's not known very widely that he was also. I'm sorry, he drafted the Evidence Act and the Contract Act. Of course, I'm going to now link what he did to sort of Field. So if we can go on to the next slide. So when Stephen comes to India, of course he's a very prominent barrister at the time. He has silk, so he's a designated senior counsel in England at the time. He would eventually go on to become a judge of the High Court. He was offered the position of Chief Justice of the Calcutta High Court, which was a very prominent position at the time. So when he comes to India, he comes and becomes the law member of the Viceroy's Legislative Council, who follows Henry Neil. And he writes letters to some of his friends, and he informs Grant Duff in Madras in 1870 that the Indian Law Commissioner's Evidence Act was very bad, a very low impression of it. And whenever Stephen mentions the Indian Evidence Act, which he has drawn up, so he makes speeches in the Legislative Council, and he says that, look, I have referred to English treatise writers, I have referred to the Indian Law Commission's draft, but he doesn't refer to David Dudley Field, and he doesn't refer to the New York Field Code. In fact, when he goes back to England, he writes a book on the Evidence Act. And in that book, he attributes the rule contained in Section 65G of the Indian Evidence Act to two common law cases. So if we can go to the next slide. Yes. Yes. That's right. So Sir Henry Neil was the law member right before Stephen. So Henry Neil had formulated the select committee which was looking at the Evidence Act, but Neil retired from the law commission from the Viceroy's Legislative Council, and then Stephen came in. So Stephen to Duff was basically complaining about how Neil had put off the evil day and put the whole burden of revising the Indian Evidence Act on his shoulders. Right. So we can move on to the next slide. So again, just to recap, Stephen had attributed in his book, once he went back to England, the rule contained in Section 65G to two English common law cases. The first of these was a case called Roberts versus Doxon in 1791. Now both of these were bankruptcy-related cases. What happens is that a witness steps into the box. It's an insolvency case, right? Someone's trying to prove that the respondent in this case is insolvent. He's unable to pay his debts. It would be comparable to a winding up petition today. So the witness steps into the box and he's asked, where are the original documents? And he says, I don't have any. I don't have the books of account of the insolvent person. But I can tell you, I've examined the books and he's insolvent. So the question arises, wait, the original documents are not before this court. So how can we allow somebody to tell us what those documents contain? And Lord Kenyon says that no, he can't tell us what the figures are. He can't say that this bankrupt person had so many pounds worth of credits and so many pounds worth of debits in his accounts. But he can generally tell us what the result of his investigation is. He can generally tell us that the person is insolvent. But the important takeaway from this case is when I read it from the authorities, and by the way, back then the law reports were basically commentaries virtually written by authors. And what I read, if you see the portions which I've extracted, which I won't read now to save time, but they don't seem to be so similar to Field's Code of 1850 and Section 65G that I can say conclusively that both Field and Stephen arrived at their drafts based on this origin. I'll go to the next case, Mia versus Septon. Again, the same thing, the same, similar case involving bankruptcy, witness section into the box. The rule which is formulated in the last paragraph says from the very nature of the case, such an inquiry could not be made in court, and therefore evidence on such a point must be given by someone who had the means of inquiry and who could state the result. So, numerous accounts and documents, general result of the whole cannot be conveniently examined in court. The words which are found in 1688 of Field's Code and in 65G of the Indian Evidence Act, they don't appear to be found in these cases. If we can go to the next slide. Likewise, we see, Stephen in his book in England referred to two authors, two English common law authors. They were Starkey and Peake on evidence. So I looked at the book Starkey and Peake on evidence, which were, by the way, very popular in the US. There were editions of Starkey and Peake available in the 1830s in the US. That's 2 decades before Field wrote his code. And Starkey and Peake refer to as a similar rule. They do refer to the rule, but the words used in the book Starkey and Peake are not so similar to both the versions of Field and Stephen that I can conclusively say that both of them got it from Starkey and Peake. So the next slide, the title is Other Hints There is Copying. So there are some hints which indicate that when Stephen came to India, he did look at David Dudley Field's code in order to draft his version of the Indian Evidence Act, particularly Section 65G. The Select Committee report in 1871, and Stephen was part of that Select Committee, said that the precedent of the New York Code was not being followed for certain things, was for presumption. So they were obviously aware of the existence of the New York Code, and they had read it, which is why they knew that there was a certain precedent that was not being followed in one case. In 1872 and 73, Stephen then speaks to the Law Amendment Society, where he says that he reveals that he has read the New York Field Code. Field himself was a very well-known figure in London. So he visited London in 1852 and 1867, where he spoke at the Law Amendment Society. Many people then praised him and said that his works would be used in the colonies as well. So the next slide. This perplexed me. I mean, why is it that when Stephen made his speeches before the Viceroy's Legislative Council, when he wrote the reports, why is it that he didn't refer to Field's Code, even though he was aware of its existence? Why did he not say that, yes, Section 65G, I relied on Field's Code as well? Why did he only say that he was referring to these two English common law cases and Starkey and Peake on evidence? Why didn't he say that he was referring to Field's Code as well? And I could come up with a couple of guesses. Right? These are all hypotheses. The first is that Field had a bad reputation for plagiarizing anyway. So at the time he had plagiarized from Taylor on evidence, who was a very well-known English common law author, without attributing his source. In fact, there was a former justice of the Australian High Court, J.D. Haven, who has pointed this out in his paper, that he pretty much plagiarized from Taylor as well. So that could be one result, that he just used to plagiarize, and it wasn't plagiarism back then, perhaps didn't have the moral connotations that it does today. The second guess is that perhaps Field felt embarrassed. He of course came from such a posh background. He had already taken silk before coming to India. He was an Oxbridge barrister. And Field was, of course, he was a wealthy lawyer who had studied at Yale, and obviously he belonged to the elite in the US. But he didn't have Field's background. He didn't have Stephen's background. So perhaps he was embarrassed to be copying from an American attorney, from a lowly American attorney. The third possibility is that Field's Code had a bad reputation in England. In 1905, in the first edition of the contract of the treatise written by Frederick Pollock and Mullah on the Indian Contract Act, so Frederick Pollock calls Field's Code about the worst piece of codification ever produced. I believe he was referring to the Contract Act. I'm not very convinced that this is a result, because I don't think that this was the opinion that was held of Field's Code in the 19th century. I believe that this is an early 20th century view that was taken on Field. I've not found anything earlier to say that field had a bad reputation in the 1860s and 1870s at the time that Stephen had taken the rule? Or could it just be, finally, that Britain was bringing law to India for what it thought was the civilizing mission in India? It thought that bringing law to India was a part of what it was giving to India. And it would seem pretty odd that that law was coming from a country which had overthrown violently British colonialism itself. So maybe it conflicted with the ideologies of the Raj. That's another hypothesis. So if we can go to the next slide. So one thing that I found interesting, which again goes to the point that plagiarism perhaps did not have the same moral repercussions and connotations as it back then as it does today, was that when he found out that his code was being used, even though no one had informed him, he was flattered and he was not annoyed. So in 1873, he made a speech before the Judiciary Committee in New York, where he talks about how his legislation, how his codes have been used in India and in the English colonies. One of his relatives then later wrote a biography of Field, in which he said that when Field traveled to India, he found that his codes were being used in India, and he could hardly believe his eyes that the rules that he had prescribed word for word in his library in New York were being used in India. So he was flattered, it seems. He was not annoyed that someone had used his work without attributing it to him. So the last few slides. Is there a question? Sorry, which sentence is? That's a great question, because I think really interested in law reform in India. I hadn't thought about how the Field's codes have affected law reform in England. So I'm not sure what the substantive changes were to the English common law and contracts at the time, in the 1870s. So that's a great question. I do know that at the time, of course, India was being considered and looked at as a laboratory for England. So all of these codes were being drawn up in India with the hope that India could be used as an experiment, and that a similar project could be enacted in England itself. And I believe that the scheme has spoken to it.
Might be the Judicature Acts in England.
Could be. I'm not sure if the Judicature Acts in England had any substantive, I need to look that up, whether there were any substantive provisions. As far as I know, the Judicature Acts dealt with, sort of the administrative setup of the courts, the merging of the common law and equity courts. But that's something that, frankly, I need to look up. I don't want to comment on that.
Okay, we move on. Okay.
Sure. So I have a slide saying "So what?" Part 1. So what's the big takeaway? So what that Stephen used Field's code in section 65G? What are the implications? So the first is purely from the standpoint of Indian law and Indian legal history. It's pretty interesting to me that Field's code was used in the drafting of the Indian Evidence Act. So one of the formative and one of the best papers that have been written on the Indian Evidence Act and its sources was written by the judge who I mentioned, a former justice of the High Court of Australia, who said that there were essentially 4 sources for the Indian Evidence Act: English law, Indian legislation, the Indian Law Commission Bill, and Hindu and Muslim law at the time. But he didn't think of Field's code. Similarly, Sarkar on Evidence, which is one of the best known treatises on the Indian Evidence Act, says that the Evidence Act is based entirely on the English law of evidence, and the industry and care with which the great mass of principles and rules of English law have been codified, and that too within a narrow compass, must need to excite the admiration and wonder of all. So Sarkar also thought that it was entirely based on English common law. And I find it interesting that actually, there was another code, there was a precedent that was drafted in New York in 1850 that was used here. So that's the first takeaway for me. If we can go on to the next slide.
Right, get there.
The second takeaway for me is it's pretty interesting and quite weird, frankly, for use of a better word, that English law, also that American law on evidence is being used in India to this day, right? Because in America there are jury trials, at least in some cases, and in India we don't have jury trials. And in India, this distinction between admissibility of evidence and the weight of something that is quite artificial. As a practicing lawyer, I find quite strange. Because effectively, in a jury system, right, it's the judge who gets to see a document. The judge will then decide whether it's admissible or not. Once the judge decides that it's admissible, the jury will see it, and then the jury will decide what the weight of the document is going to be and how relevant it is. In India, it's the judge who decides whether a document is admissible, and thereafter it's the judge who decides what the weight is for that document. So it's a pretty strange thing that the judge himself is going to see the document, whereas the entire point of the admissibility question is to ensure that the person who decides the question of fact does not get to see something which is not admissible. But the judge here is looking at the thing which is not admissible in order to determine whether or not it is admissible. So this distinction is very artificial. And so much of this really, I find it quite strange that American law is being used to this day in India. And it goes to the question of secondary evidence. As far as I am concerned, I think that that's a highly unnecessary and technical rule. That if it's secondary evidence, if it's a copy, then there has to be an entire hearing. So much time is wasted in courts on deciding whether or not something should be marked as an exhibit, which is a pretty artificial distinction. And the last slide, which is, it's pretty interesting that, and it's possible that that British colonial legislators were embarrassed to admit that the law which they were bringing to India as part of its alleged civilizing mission was law which was coming from a country which had violently overthrown English colonialism itself. So that's a pretty interesting takeaway for me. So that's pretty much it. That brings me to the conclusion of my presentation.
So thanks for the presentation, Abhinav. Do you have time for a couple of quick questions?
Yes, sure.
Okay. Does anyone have questions? I'll just relay the questions. Okay.
I heard that. So what's interesting, of course, I had to, as part of my arbitration in London, look up what the law is in India today, and I found that it's been used very rarely. It's not only been used in an accounting context. So there were land records in one case, mutation entries, registers that were referred to. And so this section 65G was referred to for mutation entries. So it's not been used in a purely commercial or accounting context. But the vast majority of the law today devotes itself to ensuring that the other side gets to see what the documents are, the underlying documents. So there's a lot of law today on ensuring that, look, while you can have the summary in evidence, you have to make the underlying documents available to the other side for inspection, because otherwise how are we to believe that the summary is in fact an accurate reflection of what's contained in the mass of the underlying documents?
Did the 1872 code in its original version also abolish juries, or have them only for criminal trials? Or
So the 1872 Evidence Act, great question. That the Evidence Act did not abolish juries, and juries, of course, were quite prevalent. This is a great question, and I know that there's some research that's been done at the University of Wisconsin-Madison by Jim Jaff, who's looking at juries. I'm yet to find prominent civil trials that were conducted by juries. So that's a question that I'd be interested in finding out, which is when did jury trials cease to exist for civil cases in India? But insofar as criminal cases are concerned, of course, we know that there were prominent cases like the Pillar case in 1908, which was tried by jury. And it's only even in independent India, there was the Nanavati trial, which was tried by jury. So jury trials in criminal cases came to an end much later. But insofar as civil cases, it's a great question. I've not really come across. I did my doctoral dissertation was on the history of the Bombay High Court. I didn't really come across many prominent civil trials that were tried before jury.
Thank you.
I had a question. Do you think another answer could be from Indian evidentiary practices? So, like Bhavani Raman in a book talks about how the local evidentiary practices is one based on memory recall, not so much on documentary practices. And I think, for example, things like the Panchnama come not from, and this is purely conjecture on my thing, come not from the English jurisprudence, but more on the practices of authentication in that were evidentiary practices in India prior to colonialism or during colonialism?
Sorry, I just got a few words. You know, the That's a great question. I mean, I've not found much evidence to indicate that pre-colonial practice is being looked at very seriously, or that there's anything to relate pre-colonial practices to Section 65G. I mean, the evidence does seem to suggest that the similarities in language between the Field Code and Section 65G seems to me to indicate that this was taken from Section 1688. But I've not found much evidence for this. Though, of course, I've not looked at pre-colonial practices in a very significant way, so I'm not sure that I have a complete answer.
Thanks for taking time out in the middle of the week. I know that as a practicing lawyer you have a busy schedule, but hopefully you will visit us more often in the future. And,
no, absolutely. Thank you so much for allowing me once again to present, and my apologies for not being there yesterday.
Thanks, Abhinav, and looking forward to seeing you in Delhi over the weekend.
Thank you. Take care.
Gauri has a power. You copy for it.
Presented kind of ties up with what we're doing in this session, the last panel, which is colonial governance in a comparative perspective from local beginnings to international endings. So it kind of ties in with it. We have three speakers for this afternoon: APARNA, BALACHANDRAN, GAURI, PARASHER, and DONAL COFFEY. And as we've done through the 2 days, we will have 20 minutes each for all the speakers. Since we started a little late here, I've been told we can go on till 4:15 if necessary. Yeah. So the first speaker is APARNA Balachandran, and her paper is on law in the city, colonialism, and urban rule in Company Madras.
Do I need to use this?
Yeah, they're recording.
Oh, okay.
You'll use a collar mic if you like.
So thank you for inviting me to speak to you today, and thank you for being here. I'm not an expert on the law by any means, and this paper is an attempt by a social historian to grapple with the possibilities of the legal archive. This paper is drawn from a larger project on urban space, law, and early colonialism in South India. And very broadly, what I'm going to try and do is to explore the shifts in the ideologies and practices of urban rule in the port city of Madras in South India from the late 17th to the early 19th centuries. So what I will do is to look at the transformation of Madras from a city-state, a hub in a worldwide network of trade and commerce, to the center of a territorial empire. And by doing so, I hope to use the lens of urban governance to think about colonialism and the law, with a particular focus on the nature of early modern empires, and I'm going to try and address the vexed issue of legal pluralism that we've talked about yesterday. Now, it would be stating the obvious to say that legal history has moved beyond the courtroom and beyond the study of the formal realms of the law. But this perspective appears particularly important in the context of early colonialism, where the law itself was more flexible and contingent and without a clearly codified or coherent set of rules and regulations. My own work looks at urban disputes involving the inhabitants of Madras over a range of issues: access to roads, rights over particular forms of ceremony and ritual, contests over rights to land, etc. Now, these are available to the historian in the company archive, usually as expressions of public disorder. The state's narratives are occasionally accompanied by other kinds of documents like inquiry reports and petitions, which in some obviously limited and mediated ways gives us an insight into the self-understanding of those involved in these incidents. Some of these disputes were adjudicated in the new courts set up by the Madras government, but many were dealt with in the streets by the police or informally by company administrators. Still others were settled in a tangled web of petitions and counter-petitions. In a very real sense, therefore, I am interested in the quotidian life of the law. In the absence of other kinds of sources, this kind of archive is invaluable for the writing of urban history, including, and again I say in limited and mediated ways, thinking about the urban imagination and sensibilities of subaltern sections of urban society. Now, the issue that I want to forefront today is what territoriality, that is territorial rule, does to the Madras government's sense of self as sovereign ruler, and how did this translate into the everyday workings of the state. I'm going to summarize a longer argument and say that Madras in the 17th and 18th centuries was envisioned as a mercantile civic space that incorporated different sections of its heterogeneous population into the processes of quotidian lawmaking and enforcement. The most dramatic example of this kind of vision was the Madras Corporation, set up in 1688 and composed not just of representatives of the important European merchants in the city, but prominent Tamil and Telugu merchants, native merchants. And as the charter setting up the corporation underlined, residency, not race, was the most important criterion for being a member of the corporation. The corporation made it clear, or the rules that underline the corporation made it clear, that in order to make decisions about the welfare of Madras, one had to be an inhabitant of the town. Unlike the Madras government itself, which all too often had to deal with the demands of the parliament and the company's headquarters in London, the policies of the corporation could not be dictated to by those who were unfamiliar with the city. So symbolically, obviously, the corporation was very important as a sign of mercantile cooperation, but it also yielded some power, not a great deal. It was an autonomous self-financing body within the Madras government. It could levy various taxes, including quit rent and scavengers' duties, in order to sustain itself. It could deal with small issues of law and order in the city, and it was also involved in settling small cases, civil cases, which had increased in tandem with commercial activities in Madras. But I'm not really interested in the corporation here, and because what I think is more interesting than the corporation itself, where membership was obviously restricted to the city's commercial elite, is the fact that this kind of incorporative governance, this idea of incorporative governance, worked at different levels. And the corporation was possibly the most spectacular example of this kind of vision of incorporative rule, but one can see the manifestation of these ideas in other governing practices. Thus, the everyday administration of the city was heavily dependent on the government's recognition of and collaboration and negotiations with local big men, periyal, of different kinds. And I'm going to talk about one kind of of Periyal, which is possibly also the most interesting, and this is the creation of the urban caste head by the government. The category of the caste head referred to leaders of groups in the city that provided the skilled and unskilled labor that was vital to the success of the Madras economy at this time, and who were in fact frequently employees of the East India Company. So the types of groups that were designated castes were bewildering in their variety, and they ranged from shopkeepers to grass cutters, from bricklayers to boatmen. They included mercantile communities like the Armenians and Portuguese, as well as the Muslim inhabitants of the city. So while colonial records refer to these groups as castes and their leaders as caste headmen, it appears that they were for the most part defined by their occupations in the city and not by their ritual standing or position in Tamil society. These local leaders were imperative to the functioning of the government. They were seen as custodians of authentic cultural knowledge. They mediated in disputes between urban groups. They communicated the demands and appeals of the groups they represented to Fort St. George, and were the conduit through which the state in turn bargained and negotiated with the latter. A particularly significant example of the role they played were in debates around urban taxation that took place at various points in the early and mid-18th century. In several notable cases, the imposition of taxes for conservancy and other works was fiercely opposed by urban communities. So you would have negotiations that would take place over days and months that were conducted with these caste headmen in order to obtain their consent, without which Parliament would not acquiesce to the move to impose these taxes. Now, what exactly was this model of governance about? For a long time, historians of trade have argued that this was an opportunistic, personalized, mercantile vision, ad hoc in practice, and seen as necessary for commercial success. Another interesting argument that's been made that is that contrary to its professed religious neutrality, the company's religious self-understanding is key to understanding this notion of rule. That is, it stemmed from a Protestant notion of Christian guardianship over a heterogeneous collection of Christians who included Protestants and Roman Catholics of various denominations, and which then this idea was extended to the city's heathen population. And it's interesting that the records themselves often refer to Madras as a new Jerusalem. Another phrase which is used is a mart of all nations, which needed a benevolent Christian ruler. But I'm going to today point to, I'm particularly interested in scholars who do comparative work on early modern empires and who have argued for a far greater degree of ideological coherence on the part of the East India Company than has been formally thought. For instance, in the South Asian context, Mitch Prass has argued that the self-understanding and functioning of Madras government in its avatar as a city-state was similar to that in other parts of the British Empire. Thus, what existed in locales as diverse as Philadelphia and Madras was that the framework of British law existed along with local legal forums and practices. The latter functioned in a variety of ways: the participation of community elites in policing and regulating social conflicts, the privileging of custom in the resolution of disputes, the attention paid to social status and the adjudication of cases, to name but a few examples. These plural legal contexts were the accepted principle that animated, therefore, for Prass, the imperial constitution of the larger British Empire. Now, Prass sees this principle at work in the functioning of the merchant courts that he looks at in his work, but one could argue that the Madras Corporation and the urban caste heads that I'm talking about come out of the same vision of rule. And certainly one of the things that is interesting is that one of the most important arguments, for instance, about taxation made by the government at Fort St. George was that Madras was like other cities around the world, whether they were Dutch or Portuguese or English, where the city's residents had to contribute to its welfare and upkeep. So in some ways, in this kind of administrative vision, Madras is detached from its actual physical locale. Its linkages and comparisons that are drawn are global ones. Now, I am going to come back to this point about the importance of the kind of deference that is paid to indigenous legal norms, to caste heads, and also to the fact that what we see well into the 19th century is the continuing existence of indigenous tribunals and forums of arbitration. Now, we had a discussion of legal pluralism in Farhad's paper yesterday, and the concept seems particularly apt to view and analyze early colonial societies that present these extremely heterogeneous legal scenarios. And the notion of pluralism allows us to make certain important analytical points. For one thing, certainly, colonial India is removed from its historiographical isolation, and locales as diverse as Madras and Batavia are now seen in the same frame. It also enables us to get away from an understanding of the encounter with Western law as being one of imposition alone. Indeed, one result of this legal heterogeneity appeared to have been a sort of very impressive manifestation of native agency in the form of forum shopping done by merchant litigants who moved between European and non-European legal forums to their own advantage. At the same time, I'd like to think a little further about the nature and functioning of this kind of pluralism as we enter the late 18th century. And I'm skipping a little bit here, but how do we think then about state law and its relationship with custom by the late 18th century as a territorial empire in South India is established? How do we account for the continuing presence of formal legal heterogeneity and the ubiquitous rhetoric of custom that governed urban governance in Madras? I would argue that the emergence and growth of a bureaucratic state by this time would result in the transformation of legal culture and norms that affected indigenous forums of adjudication as much as colonial legal spaces. And here I specifically refer to the increasing importance of the precedent and of written evidence in the settlement of disputes. And further, this importance was understood and appreciated by the company's subjects. Claims and appeals over land or ceremony, which were made in the name of customary practice, were now accompanied by written evidence. And indeed, a perusal of some of these cases reveals something quite remarkable, that in the absence of actual physical evidence, there are, the records tell us that show us these long and intricate descriptions of documents that would have confirmed the legitimacy of claims to custom if indeed they had actually existed, right? So the presence or the non-presence of this phantom evidence, complete with minute details about the state of the paper, palm leaf used, particulars of signatures and descriptions of seals of persons in authority, are a sort of strange testimony to these changing legal norms. And as Bhavani Raman has recently pointed out, this increasing emphasis on written evidence resulted in a very large number of cases of forgery that served to strengthen the discourse about native corruption. Now, as I was saying, these evidentiary norms were not restricted to forums that were formally spheres of British jurisdiction alone. And I'd like to just give you one example here. In 1800, a group of agricultural slaves belonging to the outcast Pariah caste appealed to the British government asking for freedom from what was presumably a harsh existence on the land. In this connection, the Board of Revenue received two petitions in Tamil, one from the landlord master, Venkatachalam Mudaliyar, claiming the slaves as property, and the other from the slaves themselves, hoping to be released from servitude. According to Mudaliyar, in a previous instance of the same men attempting to prove their freedom, Lionel Place, the collector of Madras at this time, had decided to hand the case over for adjudication to the Pariah headman of Madras. Neither the report in which this case is mentioned, nor Mudaliyar himself, appear to consider this act out of the way. Clearly, British courts working alongside indigenous tribunals was the norm rather than an exception that would have invited comment. Significantly, however, the Pariah headmen unequivocally rejected the appeal of their fellow castemen, stating that, and I quote, "The individuals should, according to ancient custom, serve as slaves to the memorialist from generation to generation as long as the sun and moon should endure." The basis on which this decision was made was the fact that the slaves were descendants of a woman who, a generation earlier, had, through a bond of deed or slavery, sold her entire family to the descendants of Mudaliyar. This resolution was made in 1795, and it was one of the documents that Mudaliyar provided as an annexure to make his case. The final settlement of the case is not available, But the available narrative seems to imply that the slaves were returned to their master and their claims to freedom based on their complaints of cruelty and tyranny on the part of Mudaliar were rejected. That British officials in Madras would defer to local caste courts in certain cases appears an affirmation of the coexistence of not just different forms of law, but obviously of their active encouragement by the state. However, while we have little information about the functioning of these indigenous tribunals, it appears clear that their understanding of what constituted valid evidence echoed that which was demanded by the state. In this case, written documents in the form of contracts, deeds, and bonds that agricultural slaves would certainly have no access to. The judgment of the pariah caste head, therefore, was no different from that of a colonial court that would have invariably upheld the claims of property validated by paper. While written documents were not completely absent, obviously, from the forms of acceptable evidence in pre-colonial India, it is significant that here they were the only basis on which the pariah caste headmen came to their conclusion. For the headman, this was evidence that asserted the truth of Mudaliar's claim that he had proprietary rights over his slaves according to custom. They echoed, in fact, the argument made by the Survey of Slavery in Madras in 1819 that slavery was an age-old customary practice in the region, defined and upheld by the laws of money. At the very least, the case illustrates lucidly that when the Madras government called for the participation and assistance of indigenous tribunals to arbitrate in cases that came before its courts, it did so in a context where the relations of power were very apparent. These bodies were meant to lend legitimacy to the growing power of colonial law. They did not make decisions, or did not usually make decisions, that would contradict or contest the decisions made by colonial officials. And another sort of interesting manifestation of this change was the increasing suspicion of caste headmen as untrustworthy or even dangerous. By the early 19th century, even when they were consulted, it was on matters that were about ceremonial or religious norms, and not on issues like taxation, which were now the sole prerogative of the state. I would argue, therefore, that non-state forums of arbitration, as well as notions of custom, were being transformed by the evidentiary criteria of the state, even as these spaces themselves continued to exist. The early 19th century was to see the phenomenal growth of a representational culture of claim-making, as Fort St. George was bombarded by an explosion of petitions from the inhabitants of Madras. In these petitions, as well as in administrative reports, the rhetoric of ancient custom was constantly invoked on the one hand, but the authenticity of these claims had to be validated by the evidentiary protocols of the colonial legal regime. And interestingly, by this time, the English word custom in the company records is increasingly replaced by the Persian word mamul that harken back perhaps to another moral order. But what I'm trying to also argue that this burst of petitioning has to be seen in the context of the usurpation of ideas and practices of shared governance by the state rather than as an expression of inclusive rule. A few brief points in conclusion. By looking at the transformations in urban governance, my aim is not merely to claim that the beginnings of what we think of as the quintessential state-centered colonial system of law was present rather than absent under early company rule in India. Nor is it to make a sort of false distinction between some idea of authentic legal pluralism and mere rhetoric. But it is to argue that the changing character of the state is linked to the transformations in the nature of legal heterogeneity, and this becomes apparent when one looks at the minutiae of everyday administration. The powerful invocation of custom in the administrative discourse of the early 19th century, as well as the persistence of indigenous tribunals, are paradoxically an indication of the growing authority of the state and its legal norms. The analytical gains, therefore, I would argue, of the global comparative perspective have to coexist with attention being paid to the specificities of the local and of the everyday.
Thank you, Aparna. It was GAURI to make her presentation, though the topic that has been put on the schedule is the administration of justice in French India in the 18th century. She has sought to kind of pin it down to something more specific, and I'll leave it to her to describe the topic.
Thank you. Is this on? Okay. Stop. So, I'd like to thank both Professor Mustafa and Professor Fogenauer for taking the initiative to organize what is turning out to be an intellectually invigorating workshop. And thanks also to Dr. De Quinn for inviting me and Dr. Chauhan for ensuring that I get here. Okay, sorry. So, in light of yesterday's discussion, the focus of my presentation has changed a little. One of the first points that Professor Mustafa mentioned in his introductory remarks was the question of personal laws and their codification through translation in British India. Another point that came up was Vishnu Kunaray's discussion on dispute resolution in Dravidian communities and the presence of what he called the informal justice system. And also, Professor Hassan just briefly touched upon the nature of the change in the administration of justice from Mughal India to colonial India. So in light of these considerations, I have decided to focus on one particular institution, a consultation chamber set up by the French colonial state to help administer civil justice to Indians. And focusing on this institution will not only touch upon these various elements that came up for discussion yesterday, but will also serve to highlight the French approach to administering civil justice in India. And if South India was a case of exception, to hark back to the previous title of this panel, in this regard, what was happening in Pondicherry could be construed as an exception within the exception. So, yes. So the French connection with Pondicherry began in 1672 when the French East India Company acquired a piece of land for setting up a trading post. In the 18th century, the French presence in India expanded through the establishment of further trading posts. Next one. Yeah, sorry. And in the 1950s, the company had significantly expanded direct territorial control in India and brought much of the Carnatic and the Deccan under French influence. However, by 1761, at the height of the 7 Years' War, the British had turned the tides on the growing French power and conquered Pondicherry and razed it to the ground. So Pondicherry was restored to French control after the 7 Years' War, and following which the French East India Company went bankrupt and its monopoly was suspended in 1769. And as a result, Pondicherry and other French territories came under the direct rule of the French king. But this measure, however, was no guarantee against further British occupations. For the British took the city twice more during the American War of Independence, the French Revolutionary Wars, and ultimately it was only in 1816 that, following the conclusion of Napoleonic Wars, that the city was returned to the French one last time and remained a French territory until well after Indian independence. Actually, you can go to the previous slide. Yeah, the previous one. No, the timeline, the one with the timeline. Yeah. This is just an overview. So the history of Pondicherry during the 18th century has two more or less distinct periods. The first under company rule, marked by relative stability, and then after 1765, when the town experienced a lot of political instability. And given this factor and the brevity of French rule in Pondicherry during this period, the internal history of the town has somewhat been neglected. But this period is of interest to us, for it witnessed the transition of rule from company to the king, and in its wake, the colonial states' active efforts to take charge of an area of administration that had been subject to little regulatory control previously. And it is in this context that the consultation chamber was created. So, but before we go into that, I'll just quickly explain to you, there were two quotes. Next one, please. Next one. Click once more. Yeah. So there were two quotes, main quotes for settling civil disputes among the population. The Chaudhry Court, which was situated at the marketplace, and the Conseil Supérieur, or the Superior Council. The Chaudhry was presided over by the deputy governor. He was assisted by one or two French assessors, whereas the council was headed by the governor and a varying number of councillors. Actually, it's an old word, rest house. It was actually a rest house, used to be rest houses, but it over time, actually in the pre-colonial period already, it acquired more, it also became, these Chaudhrys also became places where state representatives dispense justice. So. Exactly. Makeshift. Anyway, and this was the Place du Gouvernement, and next slide, please. And like most colonial powers, the official stance towards administering justice to Indians was basically that as different groups of Indians had their respective laws, norms, customs, civil justice had to be administered through a plurality of indigenous laws. So here we come to legal pluralism. And the French administration actively acknowledged and promulgated this policy first on the company rule and then several times over the course of the 18th century. The important thing here is that Indians did not, in Pondicherry, Indians did not change civil laws with courts, even though there was one French court, one indigenous court. And this is quite unlike what was practiced in Madras, and perhaps you can correct me if I'm wrong, where after 1726, only English law was applicable in the mayor's court, so there was this distinction. But in Pondicherry, it didn't matter which court you went to. So the majority of the Indian population was Hindus with a minority of Christians and Muslims. Now, how did the French administrators implement this policy? So the most practical solution, and as adopted by the very first governor of Pondicherry, was to let locals adjudicate disputes among themselves in keeping with their customary practices, but, however, reserving the right to ratify the final decision. So, next slide, please. Sorry, I seem to have skipped the slide, but so what the governor says is that writes to the company and says, we have also established the maxim which we believe is right for the disagreements that occur among Gentiles who have different laws and customs than ours, to oblige each party to nominate arbitrators and we judge on their report. So right from the beginning, the French administration officially actively encouraged and integrated arbitrators in the administration of justice. But in this regard, next one, please. Next one. Sorry, I'm so sorry. I think I gave you the wrong presentation. Yeah. Sorry, please excuse me. The 20. I gave him the wrong presentation, a wrong PowerPoint presentation. Yeah, but I'm having problems. Yeah. Just trying to save that. Come on, let's go. Yeah, the one next time. Oh, that's okay. No, no, it's a different one. It's okay, so, sorry about that. No problem. Thank you. Okay, so arbitrators were important since the beginning for dispensing justice. But in this context, the term arbitration designates several things. So based on the court records, it could designate an opinion proffered to the French judges on points of local customs and laws or on the particulars of the case, and in its more general sense, a settlement of dispute by a third person, either chosen by the conflicting parties themselves or appointed by the judges. So arbitration had both a consultative and an adjudicative aspect, and this is, of course, related to the fact that the term arbitration or arbitrators was a label for dispute resolution by local actors, or what Vishnu yesterday called informal forums of justice. And records from the latter half of the century show that most arbitral sentences were homologated by the French judges. So there was no conflict, so to speak, or there was no separation between the informal or the formal. It was, the French colonial state sort of incorporated these forums. And by doing so, of course, rather than sidelining them, it co-opted them in practice. And as we shall soon see, it even sought to institutionalize their functions to a certain extent. So in the period between 1669 and 1778, following the transfer of the territories to the king, there were a spate of regulations passed aiming to uniform the administration of justice to Indians. And they were promulgated at different times, and ultimately they were collated in one final regulation. And in 1778, and next slide, please. And this was the regulation, and for the next, well into the 19th century, this regulation was the model on which this regulation continued to hold sway, and subsequent changes were modeled on this. Now, the underlying, the administrators sought to do this, so to regulate the administration of justice by reconciling the ordinances of the king with the laws and customs of the Indians. So in this, I will not go into detail here, but we observe a lot of influence of French civil laws, but also of local laws that were then formally instituted. So next slide, please. So on the French side, you have French civil laws, so l'ordonnance de Louis XIV sur les matières civiles, that was the French side, and you have Tamil laws such as Panchareddy Pattiram. This was a contract law. Basically, it prescribed how a contract has to be signed by two witnesses and the scribe, as well as the contracting parties. So now it is through this regulation, the last article, if I can go to the next one. Okay, so the last article of this regulation also institutes the Chambre de Consultation. Now, this was a committee basically set up to help French judges administer justice, and it was composed of 8 individuals representing different castes and religions, and reputed for the integrity and knowledge of customs and laws of the region, as well as different castes. So the 12 articles in his founding charter basically set down the goals for the committee, prescribed its constitution, its procedures, its jurisdiction, and its prerogative, and the prerogative accorded to its members. And once again, one observes the intermingling of French and Indian laws. For example, let's just give one example. Whereas the criteria for the composition of the body are contingent on French laws. For example, the minimum age for the membership to this committee is set at 25, which was the age of civil majority in France. The forms of privileges accorded to its members are of local provenance. So Article 2 grants the members a manium, which was basically a local form of remuneration, which is a tax-free land attached to a public office. So besides helping the French judges in dispensing justice on a day-to-day basis, this committee was also charged with another goal, and that's the last article, which basically makes it, imposes on this committee as its essential duty to produce a code of Tamil laws and a collection of customs specific to each caste. Now, what is the significance of the creation of this committee? So, the first thing is it represents the institutionalization of local forums. So, the members were all caste leaders who were implicated in dispensing justice, but this was an effort to actually integrate them officially in the judiciary. And the second point of note is that, so it was because institutionalization of arbitration, the integration of Indians in the judiciary in an adjudicative capacity. And that is important because even if it was named as a consultative chamber, this was actually an adjudicative body as well, and it decided disputes. But of course, its sentences had to be homologated by French judges. And secondly, by charging it with compiling local laws and customs, this was also obviously the French colonial state's first efforts towards codifying Indian civil laws, including personal laws. So how does this committee function and as a forum of dispute resolution? Now, there are several ways of examining this question by looking at its interaction with courts, with other forums, but I will highlight 2 main points, which is the 5th and the 6th. Basically, that over the course of its functioning, it gained a lot of popularity, and it was just another forum where litigants could appeal to decisions made by other forums, and it was instrumentalized by the litigants as a way to extend their disputes. But as a result of this, the Chamber's authority also increased. Eventually, in 1796, it was actually awarded the right by the colonial state to penalize litigants for non-appearance, for misbehavior, for insulting the members. And there was even one litigant who basically sued all the members of the Chambre. And in his petition, he had very derogatory language. And as a result of this, the Chambre was given this authority for penalizing litigants. And this is important because even in its founding charter, it did not have a provision to this effect. It acquired this right over the course of its functioning. So, it strengthened its authority. So this is the list of the first members. It's 1787. These were, if you can see, chefs de la caste. They were all caste chiefs and heads of the castes. And next slide. I just discussed this. And now, so the committee functioned till 1827, and it was dismissed and replaced by another committee. Now, there were several reasons behind its dismissal, but the main one would be the change in the 19th century colonial state's perception of the body. So, as the French government notes in 1827, forgetting that it is purely consultative, the Chambre summons litigants to it, imposes fines for non-appearance, gives decisions, and has somewhat assumed the role of a tribunal. On the other hand, the uncertain, often arbitrary manner in which it examines cases causes delays that contravenes the way of justice. So there are two aspects to this criticism. The first one is that instead of viewing it both as an adjudicative and a consultative body, the state now viewed it solely as a consultative forum and accused the Chambre of actually becoming a tribunal. And as a corrective, the committee that succeeded it, its functions were reduced to being really purely consultative. And the second aspect of the criticism, and quite possibly the most irritating characteristic for the 19th century state, was the arbitrary manner of proceeding in its examination of affairs. So the Chambre's arbitrary manner of proceeding. But of course, this was a perception that was rooted in the change in what was happening in France, and it was exacerbated by the colonial administrators having been trained in a post-revolutionary metropolitan legal culture, which put a premium on uniformity and universality of law and procedures. But it wasn't just the Chambre that was which received this criticism. It was such criticism was directed towards the entire judicial system and encompassed the administration of justice in general, and inaugurated a period of extensive judicial and administrative reform. And as for the task of compiling laws, the Chambre unfortunately was unable to do it. Although there is no definite reason given in the available sources, I guess that there were several reasons. Political instability, which quite likely hindered the working of its members, and then the members changed frequently because not all 8 posts were filled at all times. Moreover, their supplementary functions, both within the judiciary and outside it, left them probably little time to compile legal treaties. So, to conclude, there are 2 main points that distinguish the French approach to administering civil justice in India. First, the French colonial state relied heavily on local actors, and rather than depriving them of their role in dispute resolution, it sought to integrate them in the administration of justice. Second, rather than turning towards pundits and ancient texts as a source of law, the French colonial state privileged custom and representatives of local castes in its first attempt to codify Indian laws. And of course, this has to do with France's own history, but yeah. Thank you.
Thank you, Gauri. Right now we have Dr. Donal Coffey and his papers on Crown and Commonwealth, legal and constitutional questions arising in the Commonwealth of Nations as a result of India's decision to declare a republic.
Good? Yeah? Hi. Good to go? Okay. Whoa. Very good. Yesterday, Professor Vogenaar gave a kind of an introduction to the idea of legal transfer in the common law world, and my research area focuses on the way in which the law of the Commonwealth is shaped by the dominions within the Commonwealth. So it's really how the law is transferred backwards rather than back from the periphery into the center as opposed to from the center out to the periphery. So what I want to look at in today's talk are basically 3 questions that are interconnected. And when I'm doing this, I will take the opportunity to correct a couple of places where I disagree with people that have written recently on the topic. So the first question is, what is problematic about India declaring itself a republic from the Commonwealth point of view at all? The second question is, how does India intend to achieve this legally speaking, and what effect does that then have on the UK? And the third question is essentially a political one, which is how do these changes that are proposed politically pass through the Commonwealth? So, the first question, what is problematic about India declaring itself a republic from a Commonwealth point of view? So in order to understand this question, we have to reverse gears a little bit. We have to go back to what is the composition of the Commonwealth in 1947. The genesis of this lies in the Colonial Conference of 1907, which gives certain elements of the British Empire the title of a dominion. And at this point in time, it applies to Canada, Australia, New Zealand, and later, Newfoundland, as well, in 1907, and is later applied to South Africa and the Free State. All well and good, they're called dominions. What does that actually mean? Well, in a kind of a classical British answer, if you ask the question, what is a dominion, they'll say, well, it's not a colony. You say, okay, why not? There the answer falls down. Brexit is Brexit. There's not really an answer to this. And the question of the characteristics that define what a dominion are change over the following 2 decades. So basically, what is a dominion, what is dominion status, is a really, really contested issue through the 1920s and 1930s. The classical definition of it occurs in the Imperial Conference of 1926 in what's called the Balfour Declaration. And it says the dominions are autonomous communities within the British Empire. Here's the first thing to remember: equal in status, in no way subordinate one to another in any aspect of their domestic or external affairs. Here's the second thing to remember: though united by a common allegiance to the Crown and freely associated as members of the British Commonwealth of Nations. So there is basically this Balfour formula, or declaration, is an attempt to marry 2 different camps within the Commonwealth. And it gives equal precedent to both of them. One of them focuses on equality of status. And this is particularly associated with Canada, South Africa, and the Irish Free State. The second one focuses on the unity of the common allegiance to the Crown, which is the UK, Australia, New Zealand, and Newfoundland. This Balfour Declaration, of course, is just a declaration of political intent at that point in time, but it's given a legal footing through the Statute of Westminster in 1931. This is a self-abnegating act, which basically says that no law passed by Westminster will apply to the dominions except if they wanted to, and also says the dominions can reverse or repeal or amend or whatever the hell they want to do with any law, any imperial legislation that has been passed which affects them. Through the remainder of the 1930s, the dominions of South Africa and the Irish Free State in particular test the boundaries of what they're basically able to get away with. So in 1935, the Irish Free State passes legislation which expressly renounced British subjecthood to our citizens. And the British expedient and the Commonwealth expedient to this measure is to simply say, well, it doesn't apply outside Ireland, so we don't care. In 1936, Ireland removes all references to the Crown from its internal constitution. In 1937, Ireland passes a new constitution which makes no reference to the Crown. However, in 1947, the position of a dominion within the Commonwealth is still essentially the one that is governed by the Balfour Declaration in 1926. Full internal self-government, but there's got to be some element of loyalty to the Crown, basically. So there's some element of common allegiance. This can change from country to country, that's fine, but it's got to be there somewhere in the mix. Because of this, it had always been accepted that the declaration of a republic would necessarily involve putting that country outside the Commonwealth. And it was tested in the case of Burma, who pursued exactly this course in 1947. And Burma declares itself a republic and immediately exits the Commonwealth. In part, this is viewed as a failure of diplomatic imagination by the United Kingdom. They simply had no way, or had thought of no way at that point in time, to contain a republic within the Commonwealth. But next up comes India, and this is a far more difficult problem from the point of view of the United Kingdom, because they're keenly aware, the UK government are keenly aware of the possibility that India will follow the Burmese example. But the geopolitical importance of India means they don't want this to happen under any circumstances. However, this problem of the Crown is recurs throughout the negotiations relating to India declaring a republic. What is India's position in this regard? So Congress initially announced its declaration to pursue a sovereign independent republic. Is there any point in time at which this declaration could be resolved from? And I want to take as a jumping off point for this question a recent article published in the Transactions of the Royal Historical Society, which concerns a discussion between Lord Mountbatten and Krishna Menon in early 1947. The conversation, at least presented in Manster's The Transfer of Power, was one-sided and essentially sees Menon concede ground to Mountbatten on all fronts. He concedes that the declaration of India as an independent sovereign republic was too hasty and extreme, and appears to be to consider the possibility, at least, of ensuring a link to the crown. The author presents the conclusion of the conversation as follows. Menon, seeing how the conversation was turning, dangled the prospect that if the British were voluntarily to give us now Dominion status well ahead of June 1948, we should be so grateful that not a voice would be heard against keeping the Crown and Commonwealth connections. Mountbatten indicated his assent to the idea which he had very clearly planted, end quote. This seems to me to be an area where the trust of Menon's diplomacy only becomes clear at the final point in the conversation, and I disagree with the author because of this. Menon really has no intention of allowing India's future status as a republic to be traded away. He simply recognizes that with the attainment of Dominion status, India can do whatever it wants. So give it to us earlier, basically. And you can actually test this proposition because Dominion status is actually granted later in 1947, so in advance of the deadline that had been set. But the Crown is still eliminated from the subsequent Constitution of India. And as a matter of fact, this element of diplomacy or this form of diplomacy is pretty much exactly the same as you see from the Burmese negotiators when they're leaving. In fact, I would say that Menon's sole purpose in holding the interview was to get this concession, and it wasn't an idea that Mountbatten planted at all. Although the British minutes, which are the basis of Manster's account, they were composed on the basis that Mountbatten had composed the idea. So we've got a problem of source blindness here. I think it unlikely, therefore, that once the commitment to a republic was made, Congress or even individuals within the Congress ever intended instead to remain a constitutional monarchy. Question 2. How did India intend to achieve this republic legally, and what effect does it have in the UK? So the Indian Independence Act 1947 provided for Dominion status and recreated in Section 6 of the Act the substantive provisions of the Statute of Westminster from 1931. The use of the phrase independence in the title of the Act in relation to India had been a fraught one, and the British government took a conscious decision in 1946 to ensure that references to Indian independence did not preclude independence within the Commonwealth. Notice that if you look at the Balfour Declaration from 26, it doesn't actually refer to independence. It refers to autonomous communities. So we've got a shift on a little bit here. Notwithstanding this grant of independence, it quickly became clear that India intended to declare a republic, but at the same time was not committed to exiting the Commonwealth. Michael Bracker points out the preeminence which Nehru had in foreign affairs and lists 7 reasons that Nehru wished to stay within the Commonwealth. 1, there would be no limitation on India's independence. 2, the danger of Indian isolation outside the Commonwealth. 3, the Commonwealth would prove useful for enhancing the prestige of India. 4th, the promotion of world stability. 5th, continuity with the British state. 6th, the promotion of Indian interests in Asia. 7th, the promotion of Indian, 7th, the promotion of Indian economic interests. And 8th, the protection of Indians in other countries in the Commonwealth. Particularly important at this point in time because of the situation in South Africa. A problematic legal area, however, was the possibility of a most favored nation case against the United Kingdom. This refers to a situation where you can have a clause in an international treaty where you will have 2 parties, and basically says if a subsequent treaty is concluded by one of the 2 parties with another third party, both parties to the initial treaty get advantage of the better treatment, essentially. So if we conclude a treaty and we subsequently conclude a treaty, you can take advantage of that. In the late 19th century, Britain began to include clauses in treaties providing that most favored nation clauses did not apply within the empire. So if they conclude a treaty with a third party and they later do something nice within the empire, it doesn't work. And it also argues that these clauses are not affected by the Commonwealth on the theory that the sovereignty of the Crown extended to all areas of the Commonwealth, and therefore Commonwealth countries were not foreign countries to which a most favoured nation suit could be applied. This made the extension of some element of monarchical constitutionalism to India imperative in the eyes of the British negotiators, so to prevent a most favoured nation suit going forward. The Indian response to this was proposed by Sir B.N. Rao in his discussion with Lord William Jowett, at that point in time the Lord Chancellor, in October 1948. And he proposed a theory of latent or dormant sovereignty. It was essentially composed of two different elements. First of all, although the king does not enjoy any sovereignty in respect of India, it could be made active by an amendment of the constitution at any point in time. Second of all, the extension of sovereignty over a territory required parliamentary authorization to be effective, and this had not at this point in time occurred in the case of India in comparison to, for example, Burma. Rao also stressed that this was a legal argument and may not be accepted politically, so he's flying a flag and seeing whether or not there's any acceptance on the other point, or on the other side. This interpretation of the Indian constitution, described as subtle as it is novel, if you are unfamiliar with bureaucratic jargonese, that means 100% wrong, was not accepted by the British legal officers. First, the law officers rejected the contention that there was no municipal law extinguishing sovereignty, as they pointed out that such a law would have to be passed shortly to regulate the matter. British law distinguished between dominions and foreign countries, but didn't have any other intermediate status. Second, they considered that the nature of the Commonwealth relationship might change, and that it might no longer be based upon the concept of allegiance to the Crown, which of course is one component of the 1926 Declaration. However, they believed that it would be necessary to appoint to a continuous and substantial tie between members of the Commonwealth subsisting before as well as after the repudiation of allegiance. This was problematic, as in the views of the law officers, such a basis did not exist. It would, in their opinion, require a de facto acceptance by civilized nations of the Commonwealth as such a community. It would require a declaration by prime ministers of the Commonwealth of such a relationship. And third, and this is the more contentious element, it would require common citizenship. The final point is obviously the most difficult to satisfy. Although Commonwealth citizenship conferred real civic benefits in the United Kingdom, and does so up until this day, as a matter of fact. If you are in the United Kingdom and you're a Commonwealth citizen, you can vote in a general election. You could vote in the Brexit vote recently. It did not do so uniformly across the Commonwealth. So, for example, in India, no such right exists for British citizens. In light of this, the law officers concluded that the Commonwealth would struggle to contradistinguish itself from South American countries who could make a much more substantiated claim to a shared common heritage. The attitude of the law officers was viewed with considerable irritation by Nehru and Menon. Nonetheless, I think it must be taken to express a key idea about the continuity of the legal relationship between the Commonwealth members, and it was also shared by political leaders, particularly in, for example, Australia and New Zealand, who really were focused on trying to retain this. I will return just at the end of the talk to the question of most favoured nation suits, but for now I want to turn to question 3. So, given that we've got this big legal issue, how does it pass through the Commonwealth at all? The one thing you have to understand about British constitutional law, and this also applies in the case of the Commonwealth and Commonwealth law, is that it's essentially impossible to separate constitutional politics from constitutional law, because there isn't a codified constitution in the same way. So in cases of conflict in the Commonwealth, the UK almost invariably chooses a political constitutional route over a legal constitutional route. And this is what happens in the British Cabinet debates that follow these initial discussions. So on November the 12th, the British Cabinet takes the decision to make the issue a political rather than a legal one. But there's an immediate fight back from representatives of Canada, Australia, and New Zealand who want to retain some element of a link to the Crown. Despite this initial opposition, it was this decision to focus on the political rather than the legal, that was the crucial turning point in discussions with India. If the legal position was a subordinate one, it allowed the crafting of a new Commonwealth relationship, which allowed India to be a republic and yet not secede. And the focus on the political realities of the case was carried on into the cabinet discussions in January 1949 and guided British policy thereafter. It was also true in the case of the other dominions. Their wish for the continuance of the legal monarchical links within the Commonwealth, which was a particular concern, was ultimately subordinated to their political wish not to be seen to exclude India from the association if it did not wish to be so excluded. And it's ultimately successful and results in the London Declaration of 28th of April 1949, where India is recognized as a member of the Commonwealth and also a republic at the same time. Incidentally, that formulation is based on the External Relations Act of 1936 in the Irish Free State, and the political impetus to that is given in a talk by Nicholas Manser, who proposes a solution in Chatham House in London in 1947. However, there's still one issue that is a little bit complicated there in relation to the Commonwealth, which is the question of South Africa, which has perplexed some observers at least. Bongiorno, for example, notes, and I quote, "The South African Prime Minister, D.F. Malan, surprised many when he endorsed Indian membership of the Commonwealth as a republic. South Africa had its quarrels with India over the treatment of Indian citizens in the Union, and his discussion with the British emissary sent to South Africa, he doubted the feasibility or desirability of retaining India. He now changed his tune, wishing to avoid the blame for having excluded India from the Commonwealth." Of course, there was a deep-seated division here, dating back at least to the 1923 Imperial Conference in London, where South Africa had said that they would not treat Indians the same as they would treat the other citizens of the Commonwealth. And this, I think, is the thing that surprises people, is why does Malan do it? But I think the explanation is actually fairly understandable if you look at South African internal politics. And the thing you have to realize about Malan is that he was incredibly stubborn, and he had fought for Republican status for South Africa, including against administrations that he was part of, under Hertzog and Smuts in South Africa, because they failed to adhere to what he viewed as being a sufficiently Republican platform. So his agreement on India, I think, is therefore to a large extent driven by this. His wish to have the possibility for South Africa to achieve Republican status and yet remain in the Commonwealth if he wants to do it at a later point in time. And of course, South Africa does do this eventually. Okay, what happens legislatively speaking? In legislative terms, the method hit upon in the UK at least is to pass the India Consequential Provisions Act 1949, which stated that unless the contrary was subsequently provided for, any reference to India was to be treated as if India had not declared a republic. In India, the Citizenship Act of 1955 recognized Commonwealth citizenship in India for citizens of other Commonwealth countries. It did not, however, recognize Indians as Commonwealth citizens. Moreover, it was clear that citizenship was a subordinate link compared to the wish to be included in the association, by the end of the negotiations at least. I just want to return to one point, which I parked in the middle of the talk, which is the question of most favored nation suits. So, what happens? The British law officers have identified an issue. There might be a most favored nation suit, and we think we'll lose it. What does the UK do? It basically just doesn't bother telling anyone and hopes that nobody will sue them. And it is successful. There's no record of any official dispute under the GATT, the General Agreement on Tariffs of Trade between 1947 and 1960 that I can find. In fact, they go even one step further. And in 1953, after India has declared itself a republic, the United Kingdom waives the strictures of Article 1 GATT, paragraph 4b, for, and I quote, items which have been traditionally admitted free of duty from countries of the Commonwealth. So the word traditionally there's a lot of lifting, because they don't actually have to be members of the Commonwealth anymore. And what you find is that in this agreement, what the UK does, it refers to Annex A of the GATT, which is formed in 1947 before India has left, includes India in that annex, and they just say, well, and everything that's in Annex A, including Burma, India, and the Republic of Ireland, we've traditionally dealt with them as members of the Commonwealth, so we're just going to keep on doing that. No reference made to the constitutional relationship that had changed in the meantime. So, what conclusions are there? I think there's only one really big conclusion, or I'm not sure if it's big, but it's a conclusion that I want to draw from this. And it relates to the manner in which politics triumphs over law in relation to this. I think this is actually something that's true not simply in relation to the Commonwealth and in relation to British legal theory in particular, but it definitely applies there. But I also think in relation to the field of legal history as well, sometimes we tend to think of things simply because they're laws as being definitive, but I think actually we always have to allow for the possibility that there is a political outcome that generates a different result, and that ultimately that is the thing that triumphs. Thank you.
I must say thanks to all the three speakers for keeping to the time, so I didn't have to do any work here at all. Okay. So now the table's open for discussion. Any questions addressed to any of the speakers? And the last session has been cancelled, so which means that we have time to finish our questions and then wind up with that.
Concepts together, and in what ways there could be a social history of law. Yeah, so that's one thing that I thought your material was quite interesting, and I want to hear a bit more on that, because that's another. And also on the question of archive, what would the engagement on South Asian legal history would have an implication in terms of thinking of the idea of archive itself, and through a lens of social history. One of the problems with the intellectual history or the conceptual history that I was talking of was in some way the erasure of the archival question. So that's one question that I was interested in. I also had a specific question in terms of your formulation about the urban space or the territorial. What would it mean for the argument if it were to be seen of Madras as an economy that is not looking towards the hinterland, but if one were to look at through perspective from, I don't know, marine or cities by the sea perspective, would that make a different implication for the kind of argument you're making? So that, in terms of also the fact that Madras is then part of a larger territoriality through the presidency system, I was just wondering in terms of the idea of speciality in your work. Yeah.
Yeah, the thing about the archive, I'm sort of trying to think about law outside formal spaces of the law. So some of the things that I've had to contend with is, for instance, looking at disputes, looking at incidents, etc., where you don't necessarily you can't see the proceedings all the way to an actual settlement, or so it is about following these trails and not necessarily seeing these in terms of a particular kind of a transformation, right? So you see the transformation in ways that are fragmented, but not in. So, for instance, there's a lot of work on custom, right, and which has to do with religious law, for instance, which talk about the how codification converts custom into something else. That's not something that you can capture in the kind of in the sort of everyday archive of the law. So that's something that I'm trying to think about in my work. But there are other kinds of issues. We were talking in the afternoon as well. For instance, this whole issue of how does one think about concepts and how do they travel. And for instance, it's intrigued me that by the early 19th century, the word, and this could have happened for many reasons, but it is the word mamul that is used and not the English word custom in the records. So obviously there's a hearkening, I think there's a hearkening back to an older order, etc. But how has the concept traveled, right? Why is it, Bharat is not here, but I asked him once, it's not a word that's used in the Mughal administration. It means habit rather than something that's used in administrative discourse, for instance. So how has it traveled to the south? Why is it so ubiquitous in administrative discourse? These are all questions that I think keep coming up, and I don't have answers yet, but this is something that these are the kinds of issues that I've been trying to grapple with. And the other thing I'd have to think about that. What I was trying to indicate is that there is a way in which it is about, Madras is seen as a, these are all port cities that the British are talking about. It is very much about cities by the sea. There is a particular kind of mercantile vision that is being articulated in this very early period. And it is this mercantile vision, I think, which produces these ideas about incorporative governance. And what happens, I think, in the later period with territory is that, for instance, questions of custom become linked to issues of land revenue. So it is a lot of the debates about land revenue that are coming from Monroe and the Rayatwari question are now sort of inflecting the whole question of the debates about custom, right? So whereas, I mean, what I think I'm seeing at an earlier period is that custom, there is this way in which it sort of hovers between talking about what is local and what is, what is an idea of what is customary in cities like these. So.
I just had a question for you, Gauri. I was just trying to understand why, when you see heard the systems in colonial India under the British as opposed to the French thing. Here, you have the separation of what was the indigenous law and the imposition of the English law, and also in terms of settling disputes, separating the Indians, from, whereas when you look at what has happening in Pondicherry, it is inclusive. Is there any explanation for it in terms of, is it something in terms of practices back in France, or it's something peculiar to what is happening here?
One main thing, the main factor is that the state doesn't have the money or the manpower to do without these local leaders. And she talked about it a little, the caste leaders, and they were also involved in the administration. So it's not just dispensation of justice, and they were the local elites, and they just can't do without them. And that was one reason. The second reason is, of course, in the codification, and that's the last point that I mentioned, this, the approach, actually approaching these men to actually compile laws, this goes back to the 16th century when France's own laws were compiled, not the entire France, but pays de coutume, basically, where there was customary law as opposed to pays de droit, which already had some kind of written form of law. And the process there, what happens in Pondicherry is very much influenced by the process there, because there also the state turned to the local leaders, to representatives of different estates, to compile the local custom. And this is something that's happening, well, at least tried in Pondicherry. So.
Yes, Professor Mustafa, and then Mayur. Okay. Take Mayur? Yeah.
So in the sense that it's not only changing your idea of custom, but the fact that people are petitioning the state changes the state's idea of law. So there's an effect upon what the state conceives as proper source of law, what the state conceives of as proper sources of what it can do, of proper forms of adjudication. So in that sense, there's a kind of a quasi-autonomy of the legal space. But in Donald's thing, it's almost like the law is almost a very transparent way of politics. Right? That same autonomy is not there in Donald's presentation. It was just more of a comment on different methodological approaches more than anything else.
Comment,
yeah, I think, okay, so if we take it that there is a kind of an ideal type when we think about law, we tend to present it as a kind of a fixed thing, and when we talk about something like the rule of law, we're talking about something that has a kind of a certain normative force behind it. And I suppose what interests me in particular about international law or law that occurs with transnational law is the extent to which we really have to challenge that notion that there is this fixity that comes with it, because it is so inherently bound up with the political that I'm not sure is it that one should maybe categorize it as simply different, which I know that some jurisprudential theories do, or whether it actually reveals something fundamental about the nature of law itself, which is something that we sublimate when we think about it in terms of domestic law. And I'm not really sure what my conclusion is in relation to that, but I think you certainly see a certain tension between this kind of idea of this, this fixed thing versus something that is not really that fixed at all when it gets to the international or transnational sphere.
Yeah, thanks, Mayur. Yeah, I think that's one of the things that I'm trying to say, that there is a way in which, of course, the emphasis on written evidence for something is something that comes from a particular kind of bureaucratic state, but it is appropriated, it becomes the norm, for instance, in these indigenous tribunals, and that there is a way in which there is a new kind of norm that is being produced, and which is used to authenticate things like custom. And I think that's important also to think about this creation of this new sort of this question of validation, the question of these norms being created in when one thinks about this, the claim that's made about the agency that is, agency is often attributed to various native litigants at this time in the act of forum shopping, for instance, right? So how do we think about things like that when you're thinking about the fact that there is actually this there's a transformation of the legal forum itself, whether indigenous or colonial?
My question, madam, is for GAURI. Just wanted to know that how do you distinguish, if you have also followed the British interaction with the personal laws, which in my opinion were different from customs. Some of the personal laws are not customs per se, and the French reaction to them. And was there any remarkable change post Code Napoleon when they were back home leading the movement for codification?
Actually, yes, all this happens in the 19th century. So I just give you the first part of the story. So this is the follow-up. Yes, because of what happens in France, there is actually a change on focus. So rather than custom then, so what happens in the 19th century is that they start paying more attention again to Sanskrit treaties and to things that have already been written. So, the idea of the ancient constitution. But because the French colonial states doesn't have a lot of money, they don't have money to pay pundits to actually do the translations themselves, what they do is they translate the English translations into French. And basically, and based on that, then they start administering justice. And slowly the successor committee, that came up in the 19th century, slowly its role is, first it is reduced to being just consultative, and then eventually it's disbanded altogether. It's completely, it's non-functional by the 1860s. But in the 19th century, they rely a lot on the English translations, which were then translated into French.
English judges' reaction, initially they relied on these pundits and Maulvis whenever matters about which they thought these people know more. Then on a given matter, X will say something and Y will say something and Z, so they got confused because they were not able to appreciate the diversity within a particular religion, So Hanafis say something and Shafi'i, or, within the Hindu law also you have different Banaras school saying something else like that. That is why when they undertook the translation. So did the similar trajectory happen in the French territories, or they simply just translated from whatever English this?
Yeah, I don't think there was confusion, but not so much, simply because the size of the territories was so diversity, you know. So it was definitely. Yeah.
My question is that, don't you think there was a very, vertical division in the society, black town and white town? So were there two dispensations also, so far justice system is concerned? I think so.
Sorry. Yes. Okay. So in the spatial distribution, and I didn't show that on the map, but yes, the Chultri was located actually in the heart of the black town, whereas the government was in the heart of the white town. But under company rule, it was quite segregated. But what happens in these, as a result of these reforms, they are actually integrated as part of one system. They are not kept segregated. And this is mainly done in three ways, where the council actually becomes an appellate court for the Chultri. So it's not that it's only for the French and this for Indians. Indians can then appeal. They have to go to the Chultri first, but then they can appeal at the council. So what happens as a result of that is that by the end of the 18th century, French judges at the council are settling more dispute among Indians than even French, because the French population anyway was only a small percentage of the total population. So that was one way. Second way was, even at the Chultri, the second way was the division of jurisdiction of the two courts over mixed disputes. So by mixed disputes, I mean disputes between Frenchmen and Indians. So this is what, and this is really interesting, whereas the Chultri could adjudicate disputes between French claimants and Indian defendants, in the other way around, so that so French defendants and Indian claimants, such disputes had to be taken to the council. Okay, so the point is that it's not that all, it's through the division of jurisdiction over these mixed disputes also, these two courts were integrated in one system, so to speak. And there was a third way that these reforms tried to integrate them, and right now it escapes me. But and appellate court, and oh yeah, and of course the making uniform by the civil procedures basically, whereas earlier it was the Ordonnance Civile of 1667, it was applicable only in the council. With these reforms, it became applicable also at the Chaudhry. So, you know, the procedures were made uniform across the board in the two courts, you know. So that segregation that had existed earlier was eventually not entirely done away with, but these were the ways that it was countered.
Any other questions?
Titling of chiefs, and you mentioned Muslim as one of those categories. Now, is there any evidence, or have you come across anything of Muslims being counted as shopkeepers, or being counted as, or were they only counted as Muslims?
They were, no, they, so I mean, I'm also trying to say that that the urban caste head is very much a sort of creation of the Madras government, and that these, no, so the Muslims, I mean, I was reading straight from my records, but I think Muslims refers to merchant communities who are Muslims. So I don't know, I mean, possibly you had shopkeepers and other kinds of, Muslims and other kinds of occupations, but they're referred to as Muslims, but I think these refer to merchant communities.
You have words like shulia, which effectively the occupation was tailors. So, and there was another occupational group, but I don't remember. But they were referred to not as Muslim, but really shulias, and that. Not as such. They were really in a minority, but there was of course the Qazi and the Mullah who were recognized as the religious leader and the as the judge, exactly, and but no other head as such.
And by the middle of the 19th century, you begin to see that these occupational castes, so these begin to disappear. So basically, you begin to see the appearance of caste in its modern manifestation. So you and what happens in the earlier period is as the British actually work with these individual caste heads, you see other kinds of caste solidarities, right? In particular, horizontal caste solidarities, the right and left hand castes, etc. Those begin to dissipate. So there is a way in which you see a new kind of caste collectivity beginning to emerge in this period, which eventually becomes the sort of the caste as we know it in the mid-19th century.
Thank you very much to the three speakers and to all the participants in the questions which enable the session to be interesting and lively. And once again, I want to thank the organizers for having invited me to be here. It's been an extremely stimulating program for me, learning new things about legal history which, you know, I hadn't even thought of earlier. So thank you very much for that.
So we had initially budgeted an hour for follow-up discussions. I think we'll scrap that because it's a small group, so obviously there's room for informal conversation. And in any case, John, Philippe and I will be following up with all of you in your own capacities. Just to say a quick sort of closing statement from our side. We began with the note yesterday where we spoke about how legal history seems to be at the margin of both mainstream history departments and these autonomous law schools. And we were very conscious of that when we got the opportunity to host a program like this. So like I've been trying to talk to all of you privately, this is a baby step for us in the sense of we don't really have much of a research agenda that we can kind of boast of so far. So we are taking baby steps in this direction. So even if you're not able to start, let's say, a full-fledged center with longitudinal projects in the immediate short run, we do hope to at least host programs of this kind more often to build some more momentum, to attract scholars who are heavily invested in this discipline from different perspectives, and maybe give them a common forum at least once a year. So certainly Professor Mustafa is thankfully going to be here for at least 6 more years. So that gives us the stability and the continuity to plan ahead. So on behalf of Nalsar, I'd like to thank all of you for accepting our invitation. John Philippe, of course, has been constantly kind of coordinating, helping us plan this workshop. I must, of course, thank Professor Vaganawal for at least initiating the process. But more than the top level, I think I should thank everybody else who's been involved in organizing the program. Mr. Chidambaram has been the one who's been doing the booking arrangements. He's not here, but we should acknowledge him. Yeah, he's the one who's been looking after everybody's travel and accommodation arrangements, and actually he's a great person to have here. He makes my life much easier when we do events. But of course, we have a lot of our staff members. Basha is here, Swami is here, a couple of others who've been helping us with recording, the staff who's helping us with the meals and the BBP hospitality. So we're all trying to build a team now. And apart from our staff, I must especially acknowledge that that while we are new to this sort of activity, it is something that we've consciously tried to do thanks to the kind of leadership change that has happened in the school in the recent past. But apart from just acknowledging those who are running the school, I think we also have to think about how the institutional reputation has actually taken us so far. So it's still a very young school. It's 18 years old. But obviously a lot of the good press about such schools has come from the alumni, students who've graduated and have done well in their respective careers. So we hope that we'll be able to persuade more of them to think about careers and scholarship and to maybe also help us in our research projects in the long run. There's one thing here, but we hope that we have more characters like Mohsen who all contribute to the school many years after graduating. So it's still early days, but hopefully we'll have, let me not cast it in your field, but more characters like you. So anyway, I think I'm going on now, so thank you again, and we look forward to seeing you more often.